Good morning. The first case to come before the court today is Village of Seville v. Chad Kilgore. You'll have up to 15 minutes to present your argument. The arguments are being recorded, so please keep your voice up and remain behind the podium. You shouldn't use the names of children or victims, minors in your argument should that be relevant. And you can refer to those people by initials or general terms. We have read your brief, and we are ready to proceed when you are. And you are Attorney Quezada?
Legal intern, Your Honor.
Okay. You may proceed when you are ready.
Good morning, Your Honors. May it please the court. My name is Diana Quesada, and I'm here on behalf of the appellant, the Village of Seville. We are here today on the issue that the trial court erred when it dismissed the case at arraignment for failure to prosecute. On February 9, 2023, officers cited Mr. Kilgore for a violation of Seville Codified Ordinance 90.01, dogs at large, an unclassified misdemeanor, for an alleged incident that occurred on October 25th, 2022.
Excuse me, unclassified misdemeanor because it doesn't state what type of misdemeanor is in the code section?
Your Honor.
Why did we conclude that that's an unclassified misdemeanor?
Yes, Your Honor, because it is in the code that it is an unclassified misdemeanor because it does not fall under any other type of misdemeanor, therefore it's an unclassified misdemeanor.
Because it doesn't specify the type of misdemeanor that it is, because it says that there's a second violation, it's an M4 in the code section.
Yes, Your Honor.
So basically you're saying because it's not specified as an unclassified.
Yes, Your Honor, therefore it's an unclassified misdemeanor, and that's what he was charged with. At the arraignment, the trial court did dismiss that charge because it stated that 105 days have lapsed between the incident and that charge, which that charge was given to him on February 9th, 2023. Ohio Revised Code 2901.13 states the prosecution is barred unless it begins prior to 6 years for a felony, 6 months for a minor misdemeanor, and 2 years for a misdemeanor other than a minor misdemeanor. As stated before, the Civil or Codified Ordinance 90.01 is a classified misdemeanor. Therefore, the prosecutor did have 2 years to bring charges against Mr. Kilgore. The 2901.13 is
Counsel, could you, just to go back a little bit, what Judge Landinger had been discussing with you, you're classifying this as a minor misdemeanor as opposed to, or a misdemeanor other than a minor misdemeanor. And can you tell me again why you're saying that as opposed to this being a minor misdemeanor?
because the ordinance does not state, so therefore it's unclassified misdemeanor because it doesn't specify that it's M1 through M4 or a minor misdemeanor. So as I was saying earlier, that 2901.13 clearly and ambiguously does say that a misdemeanor other than a minor misdemeanor has 2 years for prosecution to begin.
What are the potential penalties of the charge?
It's fines, Your Honor. There's no jail time. Correct, Your
So
Honor.
wouldn't that apply as a minor misdemeanor?
Well, in that case, the ordinance would have said a minor misdemeanor, therefore, because it does not specify, we classify it as unclassified misdemeanor.
Well, when we look at RC 2901.02G1, it says any offense not specifically classified as a minor misdemeanor if the only penalty that may be imposed is a fine not exceeding $150. So wouldn't that be applicable here?
Well, Your Honor, even if we do apply this as a minor misdemeanor, we still have 180 days to bring prosecution, 6 months. And the trial court conceded that 105 days had lapsed between the incident and the charge. So even if this court decides that this ordinance is a minor misdemeanor, the prosecution was brought well within the time of 180 days given in that statute. Therefore, either way, the court decide whether this is an unclassified misdemeanor or a minor misdemeanor, the prosecutor was well within the time frame of 180 days or the 2 year time frame. 105 days is well below that time. Therefore, that's why we are asking the court to vacate the trial court's order and reinstate this charge so we can continue with proceedings. Like I stated earlier, just to reiterate, whether this is a minor misdemeanor, an unclassified misdemeanor, only the trial court conceded 105 days have passed. Again, well below the 180 days allowed for a minor misdemeanor, or the 2 years allowed for any other misdemeanor other than a minor misdemeanor.
Let me ask, I'm sorry, let me ask you this, was there anything on the record, I mean, was there any discussion with the prosecutor and the defendant before this happened?
No, Your Honor, what occurred is the victim of this incident came to officers about it. There was some investigation, therefore that's why there was a lapse of 105 days that occurred between the incident and the charge, because she alleged more than just a dog at large violation, and after the investigation, that's when officers realized that's the only thing that the defendant could be charged on in this case. And when the arraignment was set, the defendant actually moved for a continuance, and obviously that time was told during that. And at the arraignment, once the defendant was there, that's when the defendant did mention 105 days lapse. The trial court agreed with the defendant and dismissed the charge.
And that's my point, I'm so sorry, but I was trying to get to one issue. Is there a transcript? That's why I was asking.
Yes, there is a transcript of
And
the,
did you order it, have it for us to review?
yes, Your Honor.
That was my question as well, so, thank you.
Pending no further questions from this court, the Village of Seville rests on its brief.
Any questions? Thank you very much. Thank you for your presentation. The court will take it under advisement and issue a decision in due course on the day that it is released. The clerk of courts will mail a copy of it to you, and it will also be posted on the Ohio Supreme Court website. Thank you very, very much.
And